Good morning. The committee will now come to order. The Oversight Committee's mission statement simply is that we exist to secure two fundamental principles. First, Americans have a right to know that the money Washington takes from them is well spent. And second, Americans deserve an efficient, effective government that works for them. Our duty on the Oversight and Government Reform Committee is to protect these rights. Our solemn responsibility is to hold government accountable to taxpayers, because taxpayers have a right to know what they get from their government. Our job is to work tirelessly in partnership with citizen watchdogs to deliver the facts to the American people and bring genuine reform to the Federal bureaucracy. We're holding this hearing today to learn from leaders in the Inspector General's community about the challenges they face and to learn the way that Congress can use legislation to support their work. In our mission statement, we talk about citizen watchdogs. It's a short mission statement, but it leaves out the 12,000 or so men and women of the Inspector General's corps, if you will. No greater source of sunlight on the Federal bureaucracy exists than those men and women who toil under the existing laws in which they must be independent, but they get their budget from the very people they must inspect. They must be independent, but they often are not appointed and confirmed, but acting. They must be independent, but they cannot look beyond the agency they represent. They must be independent and effective, but they can only interview people who will voluntarily come before them or who are current employees of that agency. These are some of the areas that government oversight wants to look at real reform in. IGs play such a key role in improving government efficiency and providing sunlight that this hearing is not just an opportunity for the committee to hear directly from men and women on the front lines, but in fact, a real opportunity to begin shaping a legislative change that will build on the original IG Act. IGs have proven to be one of Congress's best investments. In the last fiscal year, the IG community used their $2.7 billion budget to identify potential savings to taxpayers totaling $46.3 billion. That means for every dollar in the IG's budget, they've identified approximately $17 in savings. That would be more than enough to justify a green eye shade accountant. But IGs are more than green eye shade accountants. They are, in fact, a criminal investigation team within every agency. Often, what they find cannot be quantified in dollars, but more often is quantified in the trust of the American people. This committee, on a bipartisan basis, almost always says in every hearing, waste, fraud, and abuse. People understand waste. They kind of understand fraud. They often miss that the abuse is an abuse of power. It's an abuse of the discretion that people are given behind the scenes. IGs are often looking at exactly that, abuse of Federal employees, abuse of the public, and the like, and this is not in dollars. So today we're going to hear from three widely and highly respected IGs who have spent years examining programs at the Small Business Administration, the Justice Department, and the Peace Corps. I might note that these IGs do not oversee the largest budgets, but they oversee important agencies that are well understood by the public as having to have the trust of the American people. All these IGs have served on the legislative committees for the Council of Inspector Generals on Integrity and Efficiency, an agency that today serves more as a coordination and not as a leadership committee. It is my goal, and I've shared this with members on both sides of the aisle, that SIGI should, in fact, become a much more central and much more respected organization by the executive branch, one that we would hope the President would look to as a key place to ask questions about transparency and integrity in his or her administration. On behalf of SIGI and their representative agencies, our witnesses today will share their ideas and suggestions on how to improve the Inspector General's Act. And I hope Congress can provide the IGs and their staffs with new tools for rooting out waste, fraud, and once again, abuse. One example as part of this committee's jurisdiction and initiatives is the Bipartisan Data Act. The Data Act is not just about efficiency, it's about transparency, and it's about providing tools throughout government that would allow Inspector Generals to find the kinds of waste and the kinds of cross-cabinet programs that often are overlooked. One of them that we have seen is the result, many of them we have seen as a result of the Recovery and Accountability Transparency Board, often called the RAT Board, which tracked money not in one agency, but throughout all of the monies dispersed under the stimulus bill. I often note that I did not vote and was not given the opportunity to vote for the stimulus in a positive way. But one of my predecessors ensured that the RAT Board, the IGs, and government itself had monies in order to be accountable. And one of the great successes of the stimulus, or the Recovery Act, if you will, was in fact the Rock Center. My ranking member and I continue to support the fact that that is not just a pilot experiment that showed promise once, but in reality something that any agency would say should exist. The only question is, will it be a single cross-agency watchdog, or will there be, once again, duplications of dozens or hundreds of these centers? Certainly, when we look at how to make it work best for SIGI, how to make it work best for congressional accountability, and in the long run, how to make it work best for the Office of Management and Budget, I hope that the tool will be, in fact, a central tool bought into by the President and by future administrations. Congress can do more, though. During the 113th Congress, the committee has investigated several instances in which agency leadership undermined the effectiveness of the Inspector General. This is not to say that the Obama administration did it, because they simply happen to be those in charge today. In several cases, agencies restricted the IG's access to documents and witnesses. Yes, it's this current administration, but this is something that has to be changed, not because of a particular cabinet officer, a particular individual, but because it is a growing trend that we need to reverse. If we're to have good oversight, we need our allies in the Inspector General's office to be there for us. I want to again thank the Inspector Generals for being here today. Thank you for agreeing to help us in the reform that we seek today. I look forward to a robust dialogue, and I genuinely look forward to hearing the ranking member's opening statement, and I yield to the gentleman.
Well, thank you, Mr. Chairman, for calling this very important bipartisan hearing today. Our 72 Inspectors General are critical to ensuring that Federal agencies and programs are providing the very best possible value to the American taxpayer. Our committee, this Congress, and our nation depend on the audits and investigations IGs conduct to ensure that funds are spent effectively and efficiently, to identify issues requiring additional oversight, and to craft legislation to strengthen the operations of our government. It is critical that Inspectors General and their professional staffs have the statutory authorities they need to cast critical eyes over agencies and their programs. It is our committee's responsibility to review existing authorities, as we are doing today, to determine whether they enable the IGs to do the jobs we have entrusted them to do. In 2008, our committee passed the Inspector General Reform Act, authored by Congressman Jim Cooper, to ensure that Inspectors General are appointed solely on the basis of their professional qualifications without regard to party affiliation. The legislation also eliminated bonuses for Inspectors General and adjusted compensation accordingly. That legislation also required the President's annual budget submission to identify the budget request for each Inspector General office as a separate line item, and it created in statute the Council of Inspectors General on Integrity and Efficiency. The act was signed into law by President Bush in October of 2008. Today, we will hear testimony from Inspectors General at the Department of Justice, the Peace Corps, and the Small Business Administration. Each presents thoughtful recommendations to strengthen the authorities available to IG's government-wide efforts. Each also addresses unique issues encountered in their interactions with the agencies they oversee. I strongly support several recommendations we will hear today. In fact, H.R. 2146, the Digital Accountability and Transparency Act, which Chairman Issa authored and I co-sponsored, passed the House in the last Congress and included provisions to exempt IGs from the Paperwork Reduction Act and the Computer Matching and Privacy Act. These are the kinds of bipartisan steps we should be taking to strengthen our IGs. I have concerns, however, with some proposals that they have raised. In particular, I do not support granting our Inspectors General unfettered power to subpoena individuals to compel them to provide testimony. This would give the IGs power that even the FBI does not have. And the use of that authority could, in some instances, impede criminal investigations and raise significant civil liberty concerns. To me, the single most important thing we can do is to support the IGs. To support them is to provide them with the resources necessary to carry out the authority they have. I'm deeply concerned about the impact of budget cuts on all of our Inspectors General. I'm sure we'll hear something about that this morning. Small Business Administration's Inspector General, for example, has a double-digit vacancy rate and an ongoing hiring freeze. The Department of Justice's Inspector General testified before the Senate last year that budget shortfalls had caused him to eliminate approximately 40 positions from his staff. I look forward to hearing from our witnesses on ways to improve IG's authorities, as well as the impact that ongoing resource constraints have on their ability to conduct thorough investigations. I'm also interested in knowing how they prioritize under these circumstances, who they investigate and how they investigate it. I look forward to working with the Chairman and all of our committee members to support the critical work of our IGs. And, Mr. Chairman, with that, I yield back.
I thank the gentleman. For what purpose? Okay. All members will have 7 days to submit opening statements for the record. We now welcome our distinguished panel of witnesses. The Honorable Peggy Gustafson is Inspector General for the Small Business Administration and Chair of the SIGI Legislative Committee. A often returning guest, the Honorable Michael Horowitz is Inspector General for the Department of Justice and a member of the SIGI Legislative Committee. And last and definitely not least, Ms. Kathy Buller is the Inspector General for the Peace Corps and a member of SIGI's Legislative Committee. This is a little bit like what you would do on the other side. We, pursuant to the committee, would ask that you all rise and take the oath. Do you solemnly swear or affirm that the testimony you will give to here today will be the truth, the whole truth, and nothing but the truth? Please be seated. Let the record reflect that witnesses all answered in the affirmative. My script always says, you know, in order to allow time, make sure you stay within 5 minutes. You're all pros. You're all good at it. Your entire opening statements are placed in the record. Try to stay close to the 5 minutes because I know we have a lot of questions and we'd like to have an active dialogue, but nobody's going to do a big bell if you run a little over. Ms. Gustafson.
Thank you and good morning, Chairman Issa, Ranking Member Cummings, and the members of the committee. On behalf of the Chair of the Council of Inspectors General on Integrity and Efficiency, CIGE, I'm honored to represent the Federal Inspector and General community this morning and discuss opportunities to strengthen agency oversight through the community of Inspectors General. As noted, I currently serve as the Chair of the Legislation Committee of CIGE. Let me begin by thanking this committee on behalf of the entire IG community for your continuing support of our mission and your interest in our work. The support of this committee has been longstanding and bipartisan, and we're truly grateful for all of your support through the years. CIGE serves a leadership role and is the core of the IG community. Together, the work of the IG community has resulted in significant improvements to the economy and efficiency of programs government-wide, with potential savings totaling approximately $46.3 billion in fiscal year 2012. With our budget, our aggregate budget being approximately $2.7 billion, as noted by the Chairman, these potential savings represent about a $17 return on every dollar invested in offices of Inspector General. Notwithstanding these results, offices of Inspector General do face certain challenges. Our principal challenges pertain to independence concerns and to timely access to information. In recent years, CIGE has been advocating for additional tools to alleviate these challenges and enhance our ability to do our jobs for the taxpayers. The following are among the IG community's legislative proposals that we have been supportive of and sought through the years. Relief from the Computer Matching and Privacy Protection Act, relief from the Paperwork Reduction Act, a limited FOIA exemption to protect sensitive information security data, and some technical amendments to the IG Reform Act of 2008. CIGE feels very strongly that offices of Inspector General should be exempted from the Computer Matching and Privacy Protection Act and the Paperwork Reduction Act. These exemptions would enhance the independence of IGs and remove lengthy processes that are more aligned with the role of government interactions with the public rather than the oversight of the government entity by the Office of Inspector General. Since the Supreme Court's 2011 decision in Milner v. Department of Navy, IGs across the federal government have raised serious concerns about information related to federal agencies' information security that may be unprotected from disclosure under FOIA. Although other FOIA exemptions apply to classified information and documents compiled for law enforcement purposes, right now no single exemption currently covers the extremely important category of documents that analyze, audit, and discuss in detail the information security vulnerabilities of the federal government. So we are proposing a very narrow exception to of covering this information. And finally, we do propose some technical amendments to the Act, Representative Cooper's bill of 2008, just some very specific technical amendments. As IG, I'm grateful that IGs across the government has a voice through CIGE and have access to training and other resources that did not exist prior to the IG Reform Act. Through the Reform Act, IGs have an unprecedented degree of transparency in our annual budget requests, which help greatly in assuring our independence. That said, the IG community has been hit especially hard by uncertainty in the budget process and cuts to operating budgets. In general, all of an IG's budget is personnel, salary and expenses. And so when you are under sequestration, when you're under a straight line, that causes the type of personnel issues as noted in your opening statement, where many of us have a hiring freeze. And as noted, Representative Cummings, I right now have a 17% vacancy rate in my office, just to stay under the limits that I've been operating under in the last few years. Even with these strains on our resources, the IG community has identified and addressed a number of issues that transcend individual agencies. CIGE has reports on cybersecurity, suspension and debarment, the use of new media, hotline operations, and ERA. And all of these cross-cutting projects are always available on CIGE's website. Again, CIGE's training and professional development mission has been addressed through our training institute, and in fiscal year 2012 alone, this institute has delivered 55 training courses to 1,677 students among the IG community, representing a 17% increase in students from the previous year. This concludes my verbal statement. Thank you again so much for inviting me to talk about the issues in the IG community, and I look forward to your questions.
Thank you. Mr. Horowitz.
Thank you, Chairman Issa, Congressman Cummings, members of the committee. Thank you for inviting me to testify at today's very important hearing. The need for strong and effective independent oversight has never been more important. And while the Inspector General Act provides IGs with many of the tools that we need, I would like to highlight for you today 2 areas where my office's oversight abilities could be strengthened. To conduct effective oversight, an OIG must have complete and timely access to all records in the agency's possession that the OIG deems relevant to its review. This is the important principle codified in Section 6A of the Inspector General Act. Restricting or delaying an OIG's access to documents may lead to incomplete, inaccurate, or significantly delayed findings or recommendations, which in turn may prevent the agency from correcting serious problems and doing so in a timely manner. Most of our audits and reviews are conducted with full and timely cooperation from the Department's components. However, there have been occasions when our office has had issues arise due to the Department's view that our access was limited by other laws. For example, as this committee is aware, in the course of our Operation Fast and Furious review, issues arose regarding our access to grand jury and wiretap information that was directly relevant to that review. Similar issues arose during our ongoing review of the Department's use of material witness warrants. Ultimately, in each instance, the Attorney General or the Deputy Attorney General provided us with the permission to receive the materials because they concluded that the reviews were of assistance to them. And the Attorney General and the Deputy Attorney General have made it clear that they will continue to provide us with that necessary authorization in future reviews. However, requiring an Inspector General to obtain permission in order to receive critical documents in an agency's possession impairs an IG's independence and conflicts with the core principles of the IG Act. Simply stated, the IG Act provides an effective independent oversight requires that an IG be given prompt access to all relevant documents within the possession of the agency it is overseeing. Let me briefly turn to an issue that is unique to my office. Unlike Inspector Generals throughout the IG community and throughout the federal government, our office doesn't have authority to investigate all allegations of misconduct within the agency we oversee. While we have jurisdiction to review alleged misconduct by non-lawyers in the Department, under Section 80 of the IG Act, we do not have the same jurisdiction over alleged misconduct by Department attorneys when they act in their capacity as lawyers. In such instances, the IG Act grants exclusive investigative authority to the Department's Office of Professional Responsibility. As a result, these allegations, including those that may be made against the Department's most senior lawyers, are handled differently than misconduct allegations against law enforcement agents and other Department personnel. This jurisdictional limitation is a vestige of the fact that OPR pre-existed the creation by Congress of our office in 1988. Since that time, the Department has taken the position that OPR has specialized expertise that should result in its handling of professional misconduct allegations. Whatever merit such an argument may have had in 1988, it is surely long outdated. A similar assertion was made years ago by those who tried to forestall my office's oversight of alleged misconduct by FBI agents. That argument was rejected, and as we have demonstrated through our many investigations over the years, we have the means and the expertise to handle the most sophisticated legal and factual issues. Moreover, inspectors general across the federal government have the authority that I'm talking about to handle misconduct allegations against lawyers acting as such within their agencies. And they have demonstrated that they are fully capable of dealing with such matters. Additionally, the OIG's statutory and operational independence ensures that our investigations occur through a transparent and publicly accountable process. Unlike the head of OPR, the Inspector General is a Senate-confirmed appointee who can only be removed by the President after notification to Congress, and the Inspector General has reporting obligations both to the Attorney General and to the Congress. Enabling my office to exercise jurisdiction in attorney misconduct cases, just as we do it in matters involving non-attorneys, would enhance the public's confidence in the outcomes of these important investigations and provide our office with the same authority as other inspectors general. This has been a bipartisan issue over the years, and I hope the committee would take a close look at that. Thank you again for being invited today. I'm looking forward to any questions that you may have.
Thank you for your many good points. Ms. Buller.
Chairman Issa, Ranking Member Cummings, distinguished members of the committee, thank you for inviting me today and allowing me to summarize my prepared statements on the Peace Corps' refusal to give OIG information required by the Cape Pusey Volunteer Protection Act of 2011. This year marks the 25th anniversary of the creation of Peace Corps Inspector General. My office is small, it's 26. I have evaluators, auditors, investigators, legal counsel, and support staff. The mission of my office is to provide oversight to Peace Corps' program, which consists of 7,200 volunteers located in 65 countries around the world. Given the nature of Peace Corps' program, if the agency is not efficient and effective, the result can be tragic for both volunteers and their families. For example, in our 2010 review of the death of a volunteer in Morocco, we found significant findings that both provided closure for the victim's family and led to an overall revamp of the agency's volunteer medical care program. An effective IG must have prompt access to all relevant documents within the possession of the agency it oversees. This access is explicitly stated in Section 6 of the IG Act. We've encountered some access issues in the past that have been resolved through discussions with agency senior management. Unfortunately, we've currently reached an impasse with the agency concerning OIG's right to access information found in certain reports made by volunteers who are victims of sexual assault. The agency's policy to deny OIG access is based on the Agency General Counsel's interpretation of the Cape Pusey Act. Congress enacted the Cape Pusey Act following reports that volunteer victims of sexual assaults were being ignored, blamed for their assaults, and that their cases were being mismanaged. The Cape Pusey Act mandates extensive changes to the way Peace Corps responds to victims of sexual assault. This includes the creation of a restricted reporting mechanism allowing volunteer victims of sexual assault to confidentially disclose the details of their assault to specified individuals, receive services without the dissemination of their PII and without automatically triggering an official investigation. The Cape Pusey Act mandates that the OIG oversee the agency's implementation of the changes required by the Cape Pusey Act, as well as sexual assault mismanagement allegations. We are required to conduct a case review of a significant number of sexual assault cases, including specific incidents. We are also required to evaluate whether the agency's response was effective and implemented in accordance with law and its policies. The General Counsel's legal position is that restricted reporting provisions in the Cape Pusey Act override any obligation that Peace Corps may have under the IG Act to provide OIG with agency records. This is despite the fact that the law provides for exceptions for disclosure of restricted reported information, including one that would permit disclosure if required by a federal or state statute. Let me emphasize that restricted reports are not a narrow subset of allegations. All reports are restricted, regardless of to whom they are made, unless a volunteer changes his or her report to unrestricted. Further, agency policy unnecessarily expands the Cape Pusey Act definition of PII to include any details of a sexual assault incident. As implemented, the policy has created a blackout of information concerning restricted reports from the OIG. It defies common sense to imagine that Congress intended to increase OIG's oversight duties over the Peace Corps' response to sexual assaults while simultaneously curtailing its ability to access the information it needs to fulfill those duties. OIG's longstanding experience protecting confidentiality about victims and information about victims makes the agency's denial of OIG access even more indefensible. As Congress considers laws protecting the privacy and confidentiality of individuals with regard to information held by federal agencies, it should consider any impact on the ability of OIGs to perform the type of oversight that Congress expects and the American people expect. I would recommend that the committee make clear through legislation that OIG access to all agency documents and information is required under the IG Act, regardless of provisions contained in other laws, unless specifically stated otherwise. Hearings like this send an important message to federal agencies that OIG oversight and unfettered access to agency information is essential. Thank you again for inviting me to testify before you today, and I stand ready to answer any questions you may have.
Thank you. Thank you, one and all. I've got a few brief questions, followed up by thousands of additional ones before we make law. But, Ms. Buller, I'll take you, sort of go back in this order. To your knowledge, within the 72 IGs, in most, if not all other cases, a sexual assault access for IGs handled differently. In other words, from what you know from your participation in SIGI, are you different than other agencies in how you're handled?
We are somewhat different because of the legislation that was passed. In addition, my agency—
But theoretically, the legislation should give you more access, not less.
Exactly. As far as the IG Act is concerned, we are the same as all other IGs.
Okay. And with the other two IGs, your agencies have actually, if I understand correctly, have less trouble investigating misconduct, including sexual assault, or the same?
Well, interesting that you should ask that, and having seen IG Buller's statement, in misconduct reviews, we would normally get that information, but we have an ongoing review involving growing out of the Cartagena matter, where we are looking more systemic issues, not an investigation. And we had questions arise about access to PII and access to this information, which ironically, to the extent they existed, was sitting in our investigators' files because they get it in misconduct cases. So this is a problem we have faced as well.
Well, let me summarize the question. Currently, SIGI does not have the authority to either come to Congress or to the administration and reconcile differences of interpretation of access. Is that correct?
That's correct. As you noted, Chairman Issa, it's more a coordination role. It's a very small—
Right. They help you know what is possible, but they don't have the ability to deconflict various interpretations of various bosses.
No, they do not.
And one and all, is that something that would make your job, because some of you will spend an entire career in one agency, but often you're going to move from agency to agencies, and the level of transparency, the level of access changes. Is that correct? And that shouldn't be, obviously.
That shouldn't be. And I would just say, Mr. Chairman, that I think what IG Buller said is the fix here is the fix that should happen, which is Congress simply restates what it meant, I think, in Section 6A of the IG Act, which is notwithstanding an express provision that says an IG shouldn't get something, the presumption is if the document's in the agency's file, we have access to it, period.
Okay. Now, Mr. Horowitz, you gave me something that I wanted to bring up. This committee looked at the misconduct, the unethical behavior of the General Counsel of the Security Exchange Commission not that long ago, ultimately leading to his resignation for essentially self-dealing in the Madoff case, if you recall. If that had been your agency, as I understand it, you would have had to go to that very person or the head of the agency who handpicked that person in order to essentially get authority. Isn't that inherently cumbersome if, in some cases, you must investigate the very top of the agency?
That's correct. And indeed, there would be a serious question as to whether we even had jurisdiction pursuant to the IG Act to do that. It might go to the head of OPR appointed by the Attorney General to do that very review. We might not have any jurisdiction to do that work, even with permission.
Right. So clearly, as Congress considers changes to both how SIGI's authority is elevated, which I've made clear I intend to do, but also in the question of where you have to go individually, either somebody else has to be charged with investigating the top people in each of your agencies, or you have to be able to investigate, coordinating perhaps with FBI or other agencies. You have to be able to investigate without going to the target. Isn't that correct? You can't do that right now.
Right.
Ms. Buller, if I got the numbers correct, your staff's about 1/3 of 1% of the people, not the total staff, but just the volunteers alone, that you oversee spread over, did you say 62 countries?
65.
65. So currently you have one of the smallest staffs with one of the greatest disbursement, if you will, of people in far-flung places that may be, as we know, sadly, we've had Peace Corps volunteers raped, we've had Peace Corps volunteers kidnapped, we've had all these things that all fall under your requirement to see whether or not the care and custody questions were resolved. How do you do it with just 26 people?
We target things very strategically. Since I arrived there, we have taken more of a systematic approach to dealing with the issues that we find. When we would go and do post-audits and evaluations and we'd find the same issues over and over and over again, it had to be a problem in headquarters. It wasn't just the post.
Well, I have more questions, but no more time, so I go to the ranking member, Mr. Cummings.
Thank you very much, Mr. Chairman.
Mr. Cummings, could I just interrupt and ask Ms. Bueller if you're going to be answering questions? Would you mind putting? Thank you. Thank you, Mr. Chairman.
Mr. Horwitz, I just want to go back for a moment to some of your concerns with regard to the investigation of higher-up attorneys. I assume that you're talking about the appearance of it. In other words, that you are not able to do that in your office, and the Office of Professional Responsibility, is that the name of it?
Right.
Would have to do that. Are you talking about the way it appears? Are you complaining about cases that you've seen that you felt like you didn't have the authority to investigate, or that something went awry, that somebody was not properly investigated that you thought it should have been? Because I think we had to be kind of careful here, because what happens a lot of times is that a picture is painted of our federal employees, and particularly people in this instance who are sworn to uphold the law, and they come in and they're very independent no matter what the situation is, and they do their job. But appearance is one thing, actual problem is another. So would you comment?
Yeah, and to be clear, I'm not talking about any specific outcome or finding of an OPR report. I'm talking about two things. One is the intent of the IG Act, and I refer back to a 1994 GAO report to then Chairman Brooks in the Judiciary Committee, which laid this out as well, which is it affects it creates an organizational structure lacking the full measure of centralized control, independence, and accountability at Congress that was envisioned by the IG Act, number one. Number two, in some examples of not where I'm suggesting anything improper was done, but where this issue has arisen, for example, was in connection with the IG fire, with the U.S. Attorney firings that occurred several years ago.
Let me ask you, does your office review the conduct of lawyers acting as lawyers at the FBI or any other component of the DOJ?
We would not have jurisdiction to do that if they're acting as a lawyer.
All right.
If they were stealing money or doing something outside their legal authority, we would. But if they were making legal decisions, we do not have authority.
Now, you also wrote Inspector Generals across the federal government have the authority to handle misconduct allegations against the lawyers acting as such within their agencies. Which IGs review the conduct of lawyers acting as lawyers?
My understanding is they have authority. Every other IG has that authority to do that. That's my understanding pursuant to the IG Act. We're the only ones with the carve-out in Section 8E, because that's specific to my office.
Now, Ms. Gustafson?
Yes.
You represent the Council of Inspectors General in Integrity and Efficiency, is that right?
Yes, I'm the chair of their legislation committee.
How long you hold that position?
I think I've been chair for 3 years now.
Are you term limited?
I haven't looked at the.
I take that personally.
I hope you're not unhappy with that.
No. It just came to my mind. That's all.
He's always thinking about my term, to be honest.
So I just want to ask you a question about one legislative proposal which is to give inspectors general authority to compel testimony by subpoena. Testimonial subpoena authority is a very powerful investigative tool. Would you agree?
I would agree that that's a powerful tool. I would note that SIGI is not on our list of legislative proposals. I want to be clear that the Council of IGs right now is not advocating as a council that authority. We have in the past. That is not on our list, quite frankly.
And might I ask why it's not on your list? I mean, it's something that has always been raised.
Right.
And so I'm just curious, if you don't mind.
Well, the short answer is there is, I think, a general acknowledgement that there is a problem among our access, which is to say there are times when we cannot make people talk to us. As noted, if you're a formal federal employee, there's nothing we can do to, quote unquote, make you talk to us. There is not a consensus right now among IGs about what tool we should have in order to try to fill that gap. It's kind of like herding cats anyway, but there is not enough of a consensus that we as an organization are right now advocating for it, because there is a difference among some of us on what the tool should be, and that's why we're not advocating.
So there are some IGs, based upon what you just said, who are not anxious to have that kind of authority?
Apparently, there are some IGs who are not anxious to have that authority. That's right. When we discussed it as a group, there were some IGs who were not convinced that that was the authority that was needed. And we try to always act as a group and with a consensus, and we just felt like we didn't have a consensus.
Now, I know you have to walk a very thin line here. I got that. You're the president. Can you just tell us, it seems like it would be logical that they would want the authority. You follow what I'm saying? So I'm trying to figure out what are the arguments of saying that, well, maybe we don't want it. I mean, that's kind of unusual. And then I'll end with that, Mr. Chairman. I'm just curious.
It is unusual, and honestly, because personally I support it, but as the chair of the Legislation Committee, I'm not speaking on behalf. I think the objections that were raised were similar, Mr. Cummings, to the objections that you noted, which is not every law enforcement agency has this, the FBI doesn't have this, things of that nature, that it is a powerful authority, and some people felt unsure on whether it was the tool to need. But again, I do want to emphasize that I think it's an issue that I'm very glad is being discussed, because right now I think it has become a very real issue. There are IGs who have had problems doing either audits or investigations when people have refused to speak to them. Now, what that tool is, we're happy to work with this committee and figure out what it is, but I do hope it's a problem that we can solve.
Thank you very much, Mr. Chairman.
Thank you. And Mr. Cummings, I think if we'd asked any of these witnesses if they're frustrated when somebody chooses, perhaps after they've done something very egregious, to retire and then no longer being willing to fall under the IGs, how frustrating that is when it may not rise to an FBI investigation and yet they've slipped away from it. So I agree with all of them that we have to find a solution that they're comfortable with, in addition to the problem we understand exists.
Mr. Chairman, let me say this. I think it is important that the IGs have the authority they need to do their job, no doubt about it. I think that the question is how we bring a balance to all of that. And certainly and just as they have differing opinions, and it may be good, by the way, for us to have access to some of, maybe some of your members, and this is up to the chairman, can submit, so we can hear both sides of it, that would help us to come to some kind of reasonable solution to the problem, because obviously there are differing opinions.
I agree, and I'm certainly willing to take 72 briefs. I would ask the indulgence of all the members for a moment that are not on judiciary for something that Mr. Horowitz said that I know you didn't mean to cut him off, but Mr. Horowitz, IG Horowitz, alluded to the situation in the Harriet Miers case when obviously you were investigating and Chairman Conyers was also going forward. If there's anything you didn't say on that you think would be illustrative of that situation, I think it's important, because that led to precedent setting from a standpoint of this and other committees, and a recognition of an unusual situation. I lived you lived, many of the older members here lived through the U.S. Attorney dismissal and the inability to get good answers both here in Congress and the IG. So if you have anything, I'd love to hear it.
I was just going to point out in terms of two concrete examples where this has played out. One was the U.S. Attorney firings, where the initial decision in the Department by the Attorney General was to assign it to OPR, even though these were high-level presidential appointees. We appealed to the Attorney General. The decision was made to have it be done jointly with OPR. The second example I had just wanted to mention was the Brandon Mayfield incident involving the lawyer in Oregon who was imprisoned after a mismatched fingerprints after the bombing in Spain. That resulted in an investigation, two separate investigations. We investigated the FBI issue. OPR investigated the attorney misconduct allegations. You have our report. Our report's public. OPR's report is not public to this day. And that's an example, I think, of the institutional issue that I think has played out practically. I'm not suggesting anybody's conduct in conducting those was improper. I'm just pointing out the structural issue.
Thank you.
Thank you. Mr. Mica.
Thank you. You all have different amounts of time being either inspector generals or being in the investigation and oversight business. What's your experience, Ms. Gustafson?
I am a lawyer, like so many people. I was an assistant prosecutor many years ago. I spent 8 years as a general counsel to the state auditor.
But on the federal level?
On the federal level, I was confirmed in October of '09, and that's been my...
But before that, you did not have federal. And Mr. Horowitz?
I was confirmed as IG about 20 months ago. From '91 to 2003, I was first for 7 years in the U.S. Attorney's Office, Southern District of New York, helped run their corruption unit.
Okay. Ms. Buller?
Yeah. I've been in the IG community since 1986. I started as an attorney and then was deputy legal counsel.
You've been around a long time.
Yes, I have.
Well,
you know, this is the kind of probing that we often get criticized for, John.
I was actually looking for Mr. Duncan because I was going to say I've been on the committee. This is my 22nd year, and Mr. Duncan, who sits over here, although he looks older and more distinguished than me, I'm senior to him. And my point being that for 22 years on this committee, I've been through all the investigations, Waco, and I think we did Whitewater, and we did Travelgate. I mean, the list goes on and on. You see all the chairmen up here listed, but almost all of them, but one I think I served under. My point here is that never in my experience have I seen such difficulty in getting information from an administration. We impeached President Clinton. We went through all kinds of very difficult investigations, quite frankly. But this administration has sort of fine-tuned the art of slow-rolling us. Have you had similar difficulties? Mr. Horowitz, you have only been on for a short time, a little bit longer. Ms. Gustafson and Ms. Buller, we'll go that order.
To be clear, the issue I raised is not necessarily specific to this Attorney General, this Deputy Attorney General. It's an issue that my predecessors have had to deal with in terms of getting
But it's
opponents.
it's difficult. You don't have that long term.
But I don't have the
Okay. Ms. Gustafson.
Yeah, this is the only administration I've served under. So now I will tell you that in the auditor's office, we were slow-rolled all the time, and in the IG's office, we get slow-rolled as well. I mean, I do think it's something, it must be common to anybody who's an overseer, but whether there's a trend,
we have the same role, except from a legislative standpoint, investigations, oversight. Right. Ms. Buller?
I would say it's been something that I've experienced pretty much all my career, at least as far as having to go back and explain time and time again why it is we had access to information. I think at Peace Corps it's a little different and it's more exacerbated because Peace Corps has 5-year term limits, and so we have people coming in all the time who have no federal experience.
Well, again, I can only relay my experience from you know the dais here, but it's been very difficult. Now we're dealing with an Attorney General that you serve with, Mr. Horowitz, who we held in contempt over trying to get documents from Fast and Furious, which I think we had every right to get all of those documents. Were there restrictions or limitations on your ability to access documents during your investigation to Fast and Furious?
I came on board in the middle of the investigation.
Okay,
but my predecessor did have issues with regard to getting the grand jury and Title III materials until the Attorney General and the Deputy Attorney General intervened and wrote us the letter permitting us to get that. But it took, my understanding is, many months, and I understand that we briefed the committee staff about the problems that we were having when they were occurring, which again predated my...
I heard you say something, too. You said that you also report back to the Attorney General on these cases. So is there an instance, I mean, if there's an instance with attorneys within the Department of Justice and General Counsel's office, or as high as it gets, including the Attorney General, where does the line stop? Where is he taken out of the mix, if, for example, if he's a target?
Correct. Just to give you an example, when I came on board and as we were, we meet monthly with the Deputy Attorney General, separately monthly with the Attorney General. Other than informing them of timing about our Fast and Furious review, we did not give them updates on what we were learning as we were doing it. As I think the Chairman is aware, the first they saw it was when our draft report went for comment.
Well, my time's expired, but I'm very supportive of giving you the tools you need to, again, get your investigations and oversight completed. Thank you. I yield back, Mr. Chairman.
Okay, and just to make sure the record's clear, in Fast and Furious, you didn't have authority for the many other joint agencies that were involved in Fast and Furious, ones that were outside of justice.
Correct. So the issues that arose in DHS through ICE and others that were in our report, we would not have had authority to get those.
Yeah, and this is another part of the reform that we were talking about. Mr. Lynch.
Thank you, Mr. Chairman, and I want to thank the ranking member as well for holding this hearing, and I want to thank our witnesses for your good work. Mr. Horowitz, I know that the Inspector General's office within the Department of Justice has been at the forefront of investigating the FBI's use of confidential informants. This committee, under Chairman Waxman, under Chairman Davis, and under Chairman Burton, were intimately involved, extensively involved with the I would call it the partnership between the Boston office of the FBI and organized crime that resulted in up to 19 homicides in Boston. We had a number of FBI agents that were charged with taking gifts from organized crime. One eventually went to jail and is still there. But, and I want to say that I think that your report back in 2005 was instrumental in getting those guidelines updated. However, I have read one of your most recent reports that that indicated, and I'll quote from your report, we found significant problems in the FBI's compliance with the guideline provisions for the regarding the use of confidential informants. These violations occurred mainly in suitability reviews, whether an informant is suitable as a confidential informant because of violent activities and drug use, things like that. And in total, your report, I'm quoting again, it says, in total we found one or more guideline compliance errors in 87% of the informant files that we examined. So this continues to be a problem. I have asked several times to have hearings on this issue. We've got more problems in Boston. We've got an individual named Mark Rossetti who has been charged with, he's in a state prosecution currently, but he's been operating a far-flung criminal enterprise while under the protection of the FBI. We've got a situation down in New York where it's the similar crime family operation operating under the protection of the FBI. I've got a case down in Atlanta where one of the FBI informants was instrumental in the murder of a young man, a young rapper down there, and there are accusations that that FBI informant actually obstructed the prosecution of the confidential informant once that his involvement was discovered. So we've got a huge problem. When you talk about waste, fraud, and abuse, this is a walking advertisement. A lot of these confidential informants, and there are thousands of them, thousands of confidential informants being operated by the Office of the FBI, Department of Justice Bureau of the FBI. They committed about 6,000 crimes last year. They're required to report the number of crimes, but no details. And this whole system has just run amok. And it is totally, it is criminal on our part to allow it to continue. And I want to know from you what else we can do to get at this. They've been slow walking us. Senator Grassley and myself have been involved with the FBI trying to get information, but I think you're our best hope at getting to the bottom of this. It's a disgrace that innocent U.S. citizens should be murdered by criminal actors who are operating under the protection of the FBI. That's a goddamn disgrace. And doesn't seem to. I've written 3 letters to the current chairman to see if we get a hearing in this, but I got nothing. We seem to have a lot of time for other things that are political in nature, but we don't have time to go after this. And I'm fairly disgusted with the lack of response of Congress on this issue. I'm wondering if you can suggest to us ways that, since we're not going to do anything, since we're going to sit on our hands while this goes on and focus on other political stuff, are there things that we can help, while we're sitting on our hands doing nothing, is there anything we can do to help you actually do some good work on this issue?
Well, first of all, we're going to continue to do the oversight we're doing. As you've indicated, we've issued numerous follow-up reports, because the last thing we want to do is issue a report and then leave it be. So we're going to continue to do that, and I think your continued support and members' continued support, both to us and to alert the FBI and the leadership of the Department on the importance of these issues, the importance of follow-up is critical, as I've learned. And I'm more than happy to meet with you, Congressman, to talk about the issue further, because it is something that's core to what we do.
Thank you very much. I appreciate you being here, and to all of you, I appreciate your good work. Thank you. I yield back.
I thank the gentleman. I too appreciate each of you for being here today and your service. Mr. Horowitz, I actually did look at your bio. I didn't look at each of your bios, but I looked at yours. Impressive record and career, and we appreciate all that. Now, you worked at the Justice Department for 12 years. Is that correct?
That's correct.
And that entire time, so you worked for Bush, Clinton, Bush?
Correct.
Okay. And that entire time was in the criminal division?
Southern District of New York, and then criminal division.
Okay. And you actually headed up the criminal division at Main Justice at one point?
I was the chief of staff.
Chief of staff. All right.
And one of the bosses.
So in that 12 years experience, in the criminal division, you guys dealt with investigations dealing with the tax law?
Correct.
Probably fair amount of time, right?
Certainly we did.
And in that 12 years experience at the Justice Department, do you ever recall the Civil Rights Division investigating tax law matters?
I don't recall that during my...
You don't recall that ever happened in the 12 years you spent in the Justice Department for 3 different administrations?
I don't recall learning of that.
Okay. Now, I assume, Mr. Horowitz, that you're abreast of certain stories in the press that deal with the Justice Department. You stay abreast and you read those things?
I read clips.
Okay. Are you familiar with the name Barbara Bosserman?
From the press.
From the press, right. And Barbara Bosserman is in fact a lawyer in the Justice Department?
Based on what I've read in the press.
And based on what you read in the press, she's in the Civil Rights Division?
That's correct.
And based also what you've read in the press, although we checked this out, she is a contributor to the Obama campaign to the tune of $6,750, both the Obama campaign and the Democrat National Committee.
I only know what I've read in the press about it.
And have you also read in the press that she and Mr. Tom Perez, who was acting director at the time of the Civil Rights Division, visited the White House for a bill signing with the President?
I have no idea about that.
You're not seeing that one in this press, but all the other stuff you've read in the press.
I don't remember seeing that.
Okay. And you're also familiar with the fact that she is heading up, according to the press again, she's heading up the investigation into the IRS scandal.
That's where I've read about her involvement.
Got it. Mr. Horowitz, you know, there are a few lawyers in the Justice Department?
Yes.
Yeah. Can you hazard a guess how many lawyers in the Justice Department around the country and here at Main Justice?
At least 10,000.
10,000 lawyers. Okay.
Number precisely.
10,000 lawyers, and the one who's selected just happens to be a major contributor to the Obama campaign, also happens to be in the Civil Rights Division, not the Criminal Division, where most of the time tax matters are handled. Do you find that a little unusual?
You know, not knowing anything about the case, Congressman, other than what I've read in the press, I'd not give an opinion on that.
Okay, let me just read something to you. Again, just to get your reaction. This is from the Code of Federal Regulations for Department of Justice employees, and it says, an employee's participation in a criminal investigation should not create an appearance of a conflict of interest likely to affect the public perception of the integrity of the investigation or prosecution. You familiar with that statement, Mr. Horwitz?
I am.
Yeah, I assume very familiar with it. Yeah. Does it, and again, based on your experience at Justice in that 12-year time frame, does it appear that maybe there could be a perception that Ms. Bosserman may have a conflict of interest?
Without knowing the facts more specifically other than through the press, I think I'd defer.
But let me ask this way. Do you think maybe a typical American who understands this fact pattern could reach that conclusion? Not saying what you would reach, but you think Americans could reach that conclusion?
I guess I would ask to defer on that. I think we try to speak to what we've done and worked
Understand.
on. So
And I appreciate that. Again, you have a stellar, impressive, nonpartisan record, calling balls and strikes and doing exceptional work. I would just say for the committee, we need to remember what took place in this whole ordeal. Last spring, Lois Lerner goes to a Bar Association speech and with a planted question, breaks the story of the scandal at the IRS 3 days before the Inspector General is going to issue his report. So they jumped ahead of the Inspector General's report, which should concern all of you, certainly concerned us. 4 weeks, a few days later, the Attorney General says, we're going to get to the bottom of this, launches a criminal investigation. 4 weeks into that investigation, we had the opportunity to have then Director Mueller in front of the Judiciary Committee, and I happened to ask him 3 simple questions. Who's the lead agent? How many agents have been assigned to the case? And have you interviewed any of the victims? And 4 weeks into a criminal investigation, the FBI director said, I don't know, I don't know, I don't know. Not exactly inspiring confidence that they're getting to the bottom of this. And then we asked the FBI to brief us. They've refused to do that. And now we learn the person heading up the case is not from the criminal division, where they should deal with tax matters, and where Mr. Horwitz spent 12 years and dealt with lots of tax matters, but instead the most political division in justice, the Civil Rights Division. And just to add a little more to the story, she's a max-out contributor to the Obama campaign. And so what I'm asking, I guess for a unanimous consent of the committee, is to enter this document into the record and actually present it to Mr. Horwitz.
Mr. Chairman?
Yep.
Reserving my right to object, and I will not, I would ask equally that we enter into the record at this point my letter to Russell George, the IG you're referring to, demanding explanations for inconsistencies in his testimony before this committee.
Without objection on Mr. Connolly's so done.
I thank the Chair.
And without objection, we'll enter this into the record. But Mr. Horwitz, just finished because my time has expired. This is a letter from the Chairman and I requesting that you do an investigation into the circumstances surrounding Ms. Bosserman's selection as the person heading up the IRS investigation at the Department of Justice.
Mr. Chairman?
Recognize it, Ranking.
Just very briefly on the submittal. It's my understanding that there is law which basically says that the party affiliation of these attorneys, there's certain things that cannot be done. Is that right? I mean, are you familiar with that?
I'm generally familiar, but I would not venture, frankly, to give an opinion.
I just want to make sure that when it comes to, Mr. Chairman, it's a party affiliation, that we're careful that we're not stepping on the toes of people who are honorable people, but then their reputation gets damaged because they may have made a contribution here or there. I don't even know your affiliation. I'm not going to ask you because it's not any of my business. But I'm sure you probably made a contribution here and there yourself. So anyway, I just want us to be careful because behind these statements, Mr. Chairman, are human beings who have families, And I'm concerned about when all the dust settles here, are they still standing?
I would just point out to the ranking member, I'm not questioning Ms. Bosserman's honor, but I do think the American people may question her loyalty. When you give $6,750 to the very individual who heads the administration and you're investigating cases where that administration targeted people with differing political views, that's a real concern, especially, and I'd ask unanimous consent to enter into the record, again, the Code of Federal Regulations for Department of Justice employees, which reads, and I'll read it again just so everyone has this clear, an employee's participation in a criminal investigation, that's exactly what this is, should not create an appearance of a conflict. I don't know how you can create a bigger appearance of a conflict than the fact you maxed out contributions to the guy the administration you're supposed to be investigating of interest likely to affect the public perception of the integrity of the investigation or prosecution. And let's remember, there were 9,999 other lawyers that they could have maybe picked.
And
but
so,
no, we get Ms. Bosserman.
And so we want to go, and we want to go through the financial records.
No.
No. You listen to me.
Wait,
No. We want to go through the financial records.
No, we don't.
Apparently so.
No, we don't.
We want to go through the financial records of every attorney.
I'm asking Mr. Horowitz.
Who works
I'm
and
asking
who's
Mr.
made a
Horowitz,
contribution.
I'm asking Mr. Horowitz to find out for this committee, and more importantly for the American people, how is it that Ms. Bosserman gets picked out of 10,000 lawyers? How does that, and let's remember, he just
Point of order, Mr. Chairman.
He just testified, hang on one second, and I'll get right to you. He just testified that in 12 years in the Justice Department, in the criminal division, they dealt with all kinds of tax law issues, and to his recollection, not one time in that 12 years did the Civil Rights Division deal with tax law issues. But that's not what we have.
Point of order, Mr. Chairman.
Gentleman's
I believe the Chairman's time has expired, and there are others of us on both sides of the aisle who would like their time.
And you'll be given your full time and some extra, frankly, if Mr. Issa agrees to that. But I was responding to the ranking member's comments, who had over 5 minutes as well, I might add.
Mr. Chairman, would you yield for a question?
Mr. Cooper, who had the question? Mr. Connolly's recognized, and then Mr. Cooper's recognized.
Mr. Chairman, I hear your concern about the fact that somebody writes a check for a partisan political candidate or party that could create the appearance of a conflict. I assume the Chairman then shares my concern that that could equally apply to an IG, such as Mr. George, who wrote political checks to a political party, yours. I assume you share my concern that I mean, what's good for the goose is good for the gander, that would be equally of concern, in this case, to an IG.
Gentleman from Tennessee is recognized.
Mr. Chairman, the title of this hearing is Empowering Agency Oversight, Views from the Inspectors General Community. And I know this is the ADHD Congress, but it's very important that we try to stick to the topic. And let's hear about empowering the IG community, ideally from the IGs. A number of us have questions, like I am struck by the testimony of Mr. Horowitz. It seems like your office in DOJ and OPR have overlapping responsibilities, and I wonder whether they are in fact redundant, and maybe we need to consider merging OPR with your office, or maybe there's some sensible arrangement there, and I know that DOJ is a unique situation. My particular interest is in IGs overall, all 73, and as the author of the 2008 legislation, for my colleagues who were not here then, I need to remind you how difficult it was to pass that bill. It took many years. Why? Because the administration of George W. Bush had a veto threat out on the legislation, in particular the Office of Management and Budget, because somehow they viewed empowered IGs, professionalized IGs, as a threat. It was always beyond me. When we finally got the issue to the floor, over 400 of our colleagues voted in favor of this legislation, overcoming the veto threat that we had received from OMB. So it's important that we work through these issues on a bipartisan basis for the good of the American taxpayer. And I think we all want watchdogs inside these agencies, and we want watchdogs with teeth. Whether the agency employee who's being investigated is a lawyer or not, or whether they're overseas or not, or regardless of the circumstances. And I'm particularly interested in testimonial subpoena power so that there's not a level of fraud that's unintentionally condoned just because it doesn't rise to the level of FBI scrutiny, but these folks kind of get the street talk that know that they can get away with it just because they can't be caught. So if you could help me look at the OPR, DOJ, IG issue, and then this testimonial subpoena power, I think that would help actually address the topic of this hearing.
Thank you, Congressman, and thank you because I know you were one of the co-sponsors who, in a bill that would have addressed the very issue I'm talking about. It was a bipartisan group in both the House and the Senate that supported it, and it's a very important issue to us because it does create the potential, just as you indicated, and the Brandon Mayfield case is the best example of that I can publicly speak to, which is that was a case where an attorney in Oregon was improperly detained by the FBI due to false fingerprints. The issue was what happened on the FBI side and what happened at the department. As a result, there were 2 investigations. We did the investigation of the FBI agent alleged misconduct. The department did the review of the attorney alleged misconduct. The result was our report, as I said, is public. It's available. The other report is not. The system has worked well with regard to our oversight of FBI, DEA, ATF, all the other components, because it's simple. We have a right of first refusal. Cases come to us. If they involve senior level managers, significant misconduct or criminal violations, or pervasive mismanagement, we take it. If not, it goes back because it's relatively routine. That avoids the duplication entirely. So this is an important issue. With regard to testimonial subpoenas, there have been many instances in just my 20 months where we have seen this problem where employees resign, retire, just before they're going to be interviewed by us. One I was told that occurred before I got here involved a politicized hiring review that we did back in the mid-2000 period. The night before the interview, one of the key witnesses resigned, and we were unable to interview that employee. Now, I appreciate completely the concern about unfettered subpoena power. I don't believe for a minute that should be the case. There should be appropriate restrictions. We should make sure individuals' due process rights are covered. They should be notified of their right to counsel. There should be an advance notice to the department to protect criminal cases. There are all sorts of protections that I think absolutely need to be built into the process. But there are many instances we could cite where our ability to do full, complete reviews that you would want us to do have been stymied.
I thank the gentleman. My time has expired. I thank the chair.
I thank the gentleman. The gentleman from Utah is recognized.
I thank the chairman, and to all of you, appreciate what you do and how you do it. The IG community is so important to us. And Mr. Horowitz, I've had the good opportunity to visit with you on several occasions, and your presence and expertise in your team gives me great comfort that we're getting to the bottom of a lot of these things, and I wish you Godspeed in everything you're doing. I want to talk for a moment about the Bureau of Alcohol, Tobacco, Firearms, and Explosives, the ATF. We've had numerous issues with the ATF as a nation in the past. There is a case, it's known as Operation Fearless. This was conducted in Milwaukee, Wisconsin, and it was rife with all sorts of problems. We had a theft of an assault rifle, 2 handguns from the primary undercover agent's government vehicle, the burglary of the undercover storefront, recruitment by ATF agents of an alleged brain-damaged man to coordinate gun deals. The ATF there was paying teenagers to put a rather large-sized tattoo of a squid smoking a joint on their body to try to give some credibility to this storefront that it was involved in nefarious activities. There are a whole host of problems that I have with that in the direction that they were going. I guess what is even more troubling is that the committee became aware of some of these problems, was addressed in a letter from Chairman Issa and some other members, Senator Grassley, Chairman Issa, Chairman Goodlatte from the Judiciary Committee. They did months later provide a response, but then in the briefing, the ATF informed the Congress that this was an isolated incident. Then on December 7th, 2013, some exceptional reporting by the Milwaukee Journal-Sentinel highlighted that they were doing similar types of operations in Portland, Oregon, Wichita, Kansas, Albuquerque, New Mexico, Atlanta, Georgia, Pensacola, Florida. Are you aware of this case, and are you actively involved and engaged in reviewing it?
I am aware of the case. I was aware initially of Operation Fearless that you indicated, and then the subsequent reporting about the broader concerns on storefront operations. We have initiated, in our follow-up review of the Fast and Furious report, a look at how the controls that supposedly have been put in place, how effective they were as to Fast and Furious issues, and also how effective they've been for storefront operations like this. When the additional information was developed about further storefront operations beyond Milwaukee, what we've indicated to the committee, to the chair and ranking member, and to our other oversight committees is we are looking at those issues, because there are so many, as you've indicated, to try and understand where we should be focusing our attention in our review. We have obviously limited resources, and we want to have the greatest impact, but we are aware and we are looking at the issue.
For each of those cities as well?
For the other operations, trying to get our arms around what's out there. We've asked for briefings. We've received briefings from ATF so that we can be better informed before actually launching the review. But we will be informing the committee and our other oversight committees of the steps we're going to take in light of this.
Thank you, and I look forward to getting those briefings and understanding. You know, to my colleagues here on the dais, I think one of the concerns here, it's an ongoing trend. In Operation Fast and Furious, we were told numerous times that there were no guns that were running. There were no guns that were released. They provided that in writing. They provided that verbally, and then here we have the ATF again, telling us this is an isolated case. This hadn't happened. The consequence of this, how we get to the bottom of it, I don't know exactly how to do that. I don't know if somebody has suggestions, but is this a trend that you see? Is this do you have any suggestions on how we deal with that?
Certainly the oversight that is being done both in the House and the Senate is important. Our work and our putting forward the reports that we put forward and digging and looking for the evidence of that hopefully will be helpful to the Congress's oversight.
Now, your office made a number of recommendations in the wake of Fast and Furious. Where is ATF in the implementation of those recommendations?
We launched our review in late October, early November, right after the shutdown, of the one-year review and look back to do that. We're in the process of doing that. I'm hoping in the next several months we'll have a report for the committee and the public about our assessment of those controls.
Thank you. I yield back at 0 seconds. I want it noted for the record. Thank you, Chairman.
I see a +1, but close.